Donald Trump is a felon. So the Democrats and liberals got their political talking point finally after the sentencing of President Trump to an unconditional discharge, whatever that means. But what does this mean for your Second Amendment rights? Well, it actually means quite a bit, I suspect, because the fact is that Donald Trump has just been disarmed for the rest of his life based upon this absurd conviction in New York State court. I think this is going to get the attention of the U.S. Supreme Court and other federal judges just how absurd federal gun control law 18 U.S.C. 922 G1, barring all felons in possession of firearms. Guess what? I think it's going to help us. Let's talk about why when we come back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, and member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in the category of top voices of the 2A for the 2025 Gun News Awards in Las Vegas in just a few weeks. Looking forward to going out there, and hopefully this year we bring home the big prize. We've been a finalist in several categories over the years, have not won yet, but maybe this is the year we bring home the big trophy. I appreciate your support. All right, folks, so here's the story. I'm talking about this on Fox News quite a bit because this is a big topic, and that is Donald Trump's conviction and the sentencing, as absurd as it may be, the sentence that Judge Juan Marchand imposed of unconditional discharge. So set aside the fact that tens of millions of dollars were spent protecting President Trump going from his midtown home, downtown, and all the other nonsense that went along with this case. It all gives rise to a whimper of a conviction and a sentence of a conditional or unconditional discharge, whatever that means. It basically means there's no penalty in any real respect. Okay? Now, what a waste of time and money, unless, of course, you think that you got a political propaganda argument out here that Donald Trump is the first person ever convicted of a felony who's going to be president. I don't think it's going to last that long because I think it will be overturned on appeal. But that's not the purpose of today's video. The purpose of today's video is, can we in the Second Amendment community benefit from Donald Trump's conviction and absurd sentence in front of Judge Juan Marchand? And the answer is, I think 100% we will be able to use this to great effect in the federal court system and the U.S. Supreme Court. And what do I mean by that? You see, while the left is out there with their little boards and placards going like, Donald Trump is a convicted felon. Okay, yeah, it turns out that's the case for the moment. That's not going to last that long, but it's true for the moment. But here's the kicker. What does that mean? Well, here's where I think it's going to backfire on the anti-gunner left. And what do I mean by that? You see, Donald Trump is technically a felon because he could have been sentenced to over a year in prison, and he's labeled a felon under New York state law. As absurd as it may be for a bookkeeping set of errors with like 1,000 mistakes made by Judge Juan Marchand, both legally and factually, we don't need to get into. But the point is, technically speaking, on the law, on the books, Donald Trump today is a felon. And as a result of that, under federal gun control law, 18 U.S.C. 922 G1, you know what the answer is. Under 922 G1, if you are a felon as defined by federal law, you are not allowed to possess a firearm for the rest of your life. You are permanently disarmed as an American citizen if you've been convicted of a felony, even if the felony is as stupid and nonsensical and as absurd as this bookkeeping error argument brought about by Alvin Bragg in his district attorney's office in one county out of like the 3,000 counties in the United States in Manhattan in front of a political partisan judge in the form of Judge Juan Marchand. Now, the reason why I think this is going to be particularly significant is, first of all, it really makes the federal gun control law 922 G1 look absurd on its face. Because as of now, it's interpreted in most parts of the United States as if you've been convicted of any sort of a felony, even if it's a totally nonviolent felony, and you are totally nonviolent, and there's no evidence that you have, even the propensity to hurt a fly. Think about Martha Stewart, who was convicted of lying to the FBI, which is a felony, And no one thinks Martha Stewart could hurt a fly. And yet she is barred from having a firearm for the rest of her life because she is technically a felon as defined by 922G1. And so too now is the 78-year-old Donald Trump. Now, the reason why I think that we're going to be able to use this to great effect to fight for our Second Amendment rights is this. Just think about how crazy it is that here you have Donald Trump, who in just a couple weeks is going to have complete control over the nuclear weapons, the nuclear arsenal of the United States. He is going to be in charge of the greatest military that has ever existed. He is going to be in charge of all the nuclear weapons of the United States of America. And yet, under federal law, he is somehow viewed as so dangerous that he can't have a .38 special revolver, let's say, a 5-shot revolver. Now, this is insane and totally irrational, and just goes to show you how the gun control law of 922G1 is entirely disconnected from its policy proposal of making sure that violently dangerous people don't get access to arms. But obviously, no one is suggesting in any respect that Donald Trump is a violently dangerous guy. In fact, America has just elected him to take over our entire military and our entire nuclear weapon systems, right? Yet somehow, under the federal gun control law, interpreted by, anti-gun liberals, he can't have a handgun. And now take it to the next level, is in 4 years from now, when he leaves the White House, because right now he has bodyguards, he has got armed bodyguards, he can afford to have security, right? And even when he leaves office, Donald Trump is still going to have armed security. So really, Donald Trump, he doesn't need to carry a wallet. He doesn't need to carry credit cards. He doesn't need to carry a gun. He doesn't need to carry car keys, nothing. Because everything he does, he's surrounded by people who will do all that stuff for him, including defend his life with firearms. You see? Now, in contrast, take a look at somebody like Brian Range, who just recently won his case in the U.S. Court of Appeals for the Third Circuit there in New Jersey, Delaware, Pennsylvania. Right? Brian Range was convicted of a nonviolent misdemeanor 20-some-odd years ago for deceiving the welfare office of some income between him and his wife to get some government aid. And somehow he's been disarmed for life until the U.S. Court of Appeals for the Third Circuit just ruled in his favor and says that as applied to him, 922G1 can't apply because the whole idea, the only way, and this is the key to understand as a matter of Second Amendment law, the only basis under the Second Amendment for taking away someone's rights, okay, the only way you can take away someone's rights in any kind of a way is if they are proven to be a violent danger to someone else. So that's what the Rahimi case was about, that said that because Mr. Rahimi had been found by a court to be a violent danger to his ex-wife or ex-girlfriend there, right, and he was deemed to be a violent danger, he could be disarmed temporarily. So even Mr. Rahimi, who had a terrible record of something like 5 different shooting events and taking his ex-girlfriend's head and beating it against the dashboard of a motor vehicle and admitting that he was a violent danger to other people, including to his ex-girlfriend, despite all of that, the Supreme Court said that you could only temporarily disarm Zaki Rahimi. So that goes back to President Donald Trump. So in 4 years, Donald Trump will leave the White House at the age of 82. And for the sake of argument, picture a scenario where he doesn't have armed bodyguards. He's on his own. So somehow you've got an 82-year-old Donald Trump convicted in an absurd kangaroo court in New York in a partisan witch hunt, dealing with bookkeeping entries, purely a white-collar crime, no suggestion that Donald Trump is a violent danger to anyone or anything. And yet, 4 years from now, at the age of 82 years of age, Donald Trump would not be able to defend himself and his family with a firearm because of the single criminal conviction in front of Judge Juan Merchan. Now, this is simply absurd, and this disconnect between the one exception to the Second Amendment, which is you have the right to keep your arms, right? The right to keep and bear arms shall not be infringed. The right to keep means to possess guns. The right to bear means to carry guns. They can only take that away from you if you are shown in a court of law to be a violent danger to someone else. This has never happened with respect to Donald Trump, either in this case or any case for that matter. And it's simply absurd to think that's the case. So here you have a situation where the federal gun control law doesn't encompass someone who's capable of controlling the nuclear weapons of the United States, and also applies to a guy who no one thinks is a dangerous in any respect. There's never been a showing that the guy is violently dangerous in any respect. And yet he is now disarmed for life, permanently, inconsistently, by the way, with the Rahimi case. It says you can only be disarmed temporarily if you are shown to be a violent danger. So I think that as the 922G1 cases go forward dealing with prohibited people, meaning felons in possession, I think it's 100% the case that lawyers on behalf of the Second Amendment are literally going to talk about the problems and deficiencies with 18 U.S.C. 922G1 as applied to non-violent individuals, and they're going to use the Donald Trump case as an illustration of just how absurd this federal gun control law is. And by the way, if you ask me, if this case involving Donald Trump appeared before the United States Supreme Court, meaning Donald Trump argued that this conviction, he's going to argue, of course, this conviction should go away and he ultimately will prevail, I believe. But set that issue aside for the moment. Let's assume arguendo that Donald Trump just argues that his conviction in front of Judge Juan Marchand is not a basis for disarming him for life. And that case went before the United States Supreme Court. I think Donald Trump would 100% win that case. I think the Supreme Court would look at this and be like, 922G1 is way overbroad. There's no way that Donald Trump can lose his right to keep and bear arms for life permanently, given that he is at most a nonviolent, bookkeeping, error-ridden, nonviolent felon who has never hurt a fly. So again, I think that the fact that Donald Trump was convicted and sentenced, although I disapprove of it and I think it was totally wrong and a terrible waste of resources, money that could have been spent in New York on protecting Americans, let's say on the subway, from people who try to burn them to death. But set that issue aside, and obviously we know the political propaganda effort by the lawfare against Donald Trump didn't work because Donald Trump won the election in November. So none of this worked, but still it does go to show you, and I think it's a favorable development, that we're going to be able to use Donald Trump being disarmed for life as a way to attack and narrow and fight back and narrow the scope of the applicability of federal gun control law 18 U.S.C. 922G dealing with the so-called felons in possession rules. And I think, again, this is ultimately very good for the Second Amendment as judges begin to think about the question, because historically they said, what about Martha Stewart? But now this is much more contemporaneous with modern life, right? They're going to be like, well, what about why would Donald Trump lose his gun rights for life given that case and the fact he controls the nuclear weapons? And I think that hypothetical, which is not a hypothetical anymore, it's a reality, is going to cause a lot of federal judges to think long and hard about, is 922G2 as applied to non-violent felons, is it constitutional under the Second Amendment? And I think the answer to the question is undeniably no, which is the same decision that was reached in the Brian Range case in the Third Circuit just several weeks ago en banc, dealing with Brian Range and his non-violent misdemeanor conviction 20 years ago, which I think will ultimately get to the U.S. Supreme Court, but we'll see how that plays out over the next several months. All right, folks, well, hope you enjoyed this episode talking about Donald Trump, his Second Amendment rights being permanently disarmed, and his conviction in front of Judge Juan Marchand. Make sure you follow me on X @ForBoxStar. Don't forget to subscribe to me both on Rumble and YouTube. We're trying to grow the channel on both platforms now. And make sure you share this video long and wide and with all your friends and all that good stuff. And again, I look forward to talking with all of you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.